Hello, and thank you for joining with me today. In this video, we will take a look at the terms of service agreements and whether these documents can be perceived as contractual agreements. Specifically, we will be looking at Priceline.com's terms and conditions and whether this agreement is enforceable under current laws. I will discuss the obligations that both Priceline and the user has under the terms and conditions agreement. Lastly, I will discuss my suggestions to make this statement more legally binding and personal with Priceline users. Let's get started. Most of us are familiar with the travel service provider company, Priceline.com. We've either used its website to help us book a discounted hotel, flight, or rental car, or have seen their ads on TV or online. I enjoy the storyline with Big Bang Theory star Kaylee Cuoco, now acting as the Priceline negotiator's long-lost daughter in these ads. Having an ongoing storyline really engages the audience and potential users. Online travel service provider sites have become popular with travelers because they can offer deals as a third party that you may not necessarily get when talking directly to the airline, hotel, or rental car company. Plus, many of these websites make it easy to book everything on one website. However, before using an online website, a consumer should always read the term of service agreement before signing or agreeing to the document. Terms of service policies on websites define how Internet businesses interact with you and use your personal information, according to Electronic Frontier Foundation. About.com defines it in simpler terms, saying that terms of service explains what actions are allowed and disallowed while using the website. We have all probably run into these documents at some point, whether they're buying or downloading things from the Internet. It is a page that pops up and asks you to click the I agree button. When you click the I agree button, you are electronically signing this document, legally binding you to the terms of the contract. Under the Federal E-Sign Act of 2000, no contract can be denied because it is in electronic form or it has electronic signature. While there is no standard definition of what constitutes for electronic signature, click-wrap agreements, such as Priceline's Terms and Conditions document, have been upheld because the user can read and understand that they are entering a contract. Yet, just because a contract is legal doesn't mean that all aspects of the document are enforceable. At the beginning of the Priceline Terms and Conditions, it states, "By accessing any areas of this site, users agree to be legally bound without limitation, qualification, or change, and to abide by these terms and conditions which will constitute our agreement." This language makes it clear that this document is an agreement. Yet, they cannot enforce the agreement until a customer agrees to the contract. A person cannot be bound by these terms and conditions just by visiting the website until the contract has been signed. Many websites, including Priceline.com, include a provision in the policy that say they can change the policy whenever they want without notifying the user, and it is the user's responsibility to periodically read the document to see if any changes have been made. While this clause was intended to allow the company to update and change its policies when needed, it does not hold up well in court. In the Douglas v. Talk America case in 2007, the Ninth Circuit Court stated that parties to a contract have no obligation to check the terms on a periodic basis to learn whether they have been changed by the other side. So while many of these agreements state something similar in their contracts, it is not easy to uphold these in court and may even risk killing the entire contract. The Priceline Terms and Conditions contract holds the user responsible for the majority of obligations in the agreement. The user is obligated to abide by the copyright and trademark clauses in the agreement. These are pretty standard. Most websites have them so that the owner of the website can protect their intellectual property. The user is also bound by a user license, which states 14 specific things you cannot do on the website. While the user has all of these and more obligations, Priceline slinks back from most of the responsibility of what happens on their site. Priceline will not even take the responsibility of the security and safety of their website. So if your information is stolen or your computer contracts a virus while using Priceline.com, Priceline cannot be held accountable. When booking a request on the website, a booker is held accountable for all actions, even if they are booking for another person. The booker is responsible for making sure that all information is correct, all charges to Priceline.com have been made, and any performance obligations. This is important to know when booking travel plans for other people, which I have personally done on several occasions. This is a great reason why you should always read the terms of service contracts and know what you as a user are responsible for. Under the comment section of the agreement, it states, Priceline.com does not represent or guarantee the truthfulness, accuracy, or reliability of any comments or determine whether comments violate the rights of others. You acknowledge that any reliance on material posted by other users will be at your own risk. This relieves Priceline from any accountability or obligation that appears in the comment section of the website. However, in this section, it also says that all comments become the property of Priceline.com and can be used for any promotional materials for the company, including your name and location. Again, this is why you always need to read the terms of service agreements. Throughout the whole document, there's only one thing that Priceline.com takes responsibility to accomplish. It states, if your credit card has already been charged for the purchase and your request is canceled because of incorrect travel service provider information, we will promptly issue a credit to your credit card account in the amount of the charge. This means that Priceline.com is only obligated to give you a refund if your request is canceled because of incorrect information on the website. If your request is canceled for any other reason, you may not receive a refund from Priceline. The last section of this agreement that I want to look at is the miscellaneous section. This paragraph repeats the idea that they have the right to change these terms and conditions, and that just by continuing the use of the website you are subject to these changes. It also states, in the event that any provision of this agreement is determined to be unenforceable or invalid, such provision shall nonetheless be enforced to the fullest extent permitted by applicable law, and such determination shall not affect the validity or enforceability of any other remaining provisions. The enforceability of some or all of this contract will be determined by the court. And while this does help protect Priceline.com from getting the whole document dismissed due to a technicality, I believe that this sentence is overreaching and is itself not enforceable. Now that we have discussed the document's obligation, enforceability, and legitimacy, let's talk about how this contract meets its purpose and what changes can be made to make this contract more legally binding. Dang it.